There's a handout for this talk in the back that's titled Drafting Conservation Easements Practical Pointers, if you want to get one. This half-day session was initially conceived as a conservation easement drafting workshop for land trust and has morphed into a legacy planning workshop for landowners, which is very needed, but I am the remaining token land trust representative on the panel. My comments will be more directed to land trust, but landowners, if you'll hang with me, pretty much everything that I'm going to say is going to come back around to something that is very important to landowners, and that is whether or not a conservation easement contribution is tax deductible. I hope it's not too much inside baseball, so I'm going to try to make it as relevant for landowners as I can. I want to begin with something that David Hartman touched on, and that is the importance of the purpose clause and recitals clause. Everything in the conservation easement flows out of the purpose clause. The recitals clauses are the whereas clauses, and the recitals have three purposes. It sounds funny. There are three reasons that we have the recitals, the whereas clause. One is it's where you tell the story of why you're doing this particular conservation transaction. And secondly, it's where you name the conservation values that you're trying to protect. And thirdly, it's where you make the case that it's a tax-deductible contribution. The reason that I mention this is that there are still some templates floating around, largely from federal agencies, that are simply platitudes. They have a bare purpose clause and then recitals that would apply to any property anywhere in the country. We really need, as David mentioned, to have the purpose and recitals together describe the conservation values to be protected with specificity. There are a couple of examples in the handout. One is a rather economical statement of purpose and recitals, and the second one is a more detailed recitation of purpose and recitals that was adapted from a transaction Thomas and I did a couple of years ago. Another inside baseball clause for us working with conservation easements is a no inconsistent use clause that you'll see that reads something like, grantor will not perform nor knowingly allow others to perform any act on the property that is inconsistent with the purposes of this conservation easement. And a lot of times landowners, or more specifically landowner attorneys, will object to this, saying that's too vague. I don't know how to comply with this. Well, learn to love it. It's required by the IRS regulations for tax-deductible contributions. All activities on the property have to square up with the purposes. So this is not optional language. Another important clause is the property use clause, that is the language that introduces the restrictions and reserved rights. The meat and potatoes of a conservation easement are the restrictions and the reserved rights. That's where the landowner says, I want to have 2 building envelopes with houses, I want roads that go here, I want to do this kind of agricultural activity. The property use clause introduces that, and there are still some templates floating around that have obsolete property use clauses that are unfair to one party or the other. Here's a couple of examples. One is, all uses are permitted that are not expressly prohibited. I still see that. Land trust, you can't anticipate all possible uses. If a landowner thinks that they have reserved the right to engage in an activity that's not prohibited, but it does impact conservation values, that could create some friction and cause problems for both parties. The flip side of that is all uses not expressly permitted are prohibited. Now, you'll see some U.S. Army Corps of Engineers conservation easements where essentially they're retiring the property. Once that easement goes on, all you can do on it pretty much is walk, hunt, fish, and that's about it. But for 99-point-something% of conservation easements, this is putting the landowner in a box. They can't anticipate all possible uses, and it's going to create problems down the road for both the landowner and the land trust. Here's one that I like a lot better. It incorporates the no inconsistent use clause in the first sentence. It says, any activity on or use of the property inconsistent with the purposes of this conservation easement is prohibited. It starts with the purpose. Without limiting the generality of that, the following is a listing of activities and uses which are expressly prohibited or which are expressly allowed. And that's where you have your structures, your roads, your agricultural uses, and so on. Continuing on the theme of unanticipated uses, Thomas and I, in a number of easements, have concluded the restrictions and reservations with an unanticipated uses clause that addresses activities the landowner does not currently carry on. The landowner is going to want to be able to carry on all existing activities. This addresses unanticipated activities. To quote my favorite philosopher, Yogi Berra, it's hard to make predictions, especially about the future. So here's a clause that Thomas and I have used. Any unanticipated use or activity on the property which could materially impact significant conservation values is prohibited. No one should care if it's an unanticipated activity that has no impact on conservation values. But if it might impact conservation values, it may work out that holder may permit certain unanticipated uses if such use or activity would not materially impact significant conservation values subject to holder's discretionary consent. What this means is, holder thinks, you know, I want to do this. It's not addressed in my conservation easement. Pick up the phone, call the land trust. I want to do this. The land trust says, would you please write it up and send it to me? They consider it, and then ideally will write the landowner back saying, we have considered your request for this activity and it's approved. That papers up for both the landowner and the land trust that this use or activity that's not addressed in the conservation easement is permitted. Okay, what's your name sitting behind Allison? You, yeah. David, you're the person sitting closest to the speaker. So I'm going to give you the first chocolate bar of 2013. You can share it. Takes guts. No, I know you're trying to sleep, Corky. So, okay, I just wanted to take a little pause before I get into the next part. And this is going to be, I think, of more interest to landowners. And that is, anyone involved in conservation the last few years knows that the IRS has been aggressive about auditing conservation easement donations and has come up with what we think are very imaginative and very thin reasons for denying what is otherwise a very valuable contribution. The IRS in the last year or so has taken the position that parties to a conservation easement must demonstrate that exercise of reserve rights will not adversely affect conservation interests. They're essentially asking us to prove a negative. Such as it is, that's what we're dealing with. We're just learning how and figuring out how to deal with this new aggressive tactic by the IRS. But I am recommending for now the inclusion of a very blanket statement in the baseline that holder has determined that the exercise of grantor's reserve rights will not significantly impact conservation interests associated with the property. This kind of puts the IRS on notice that we're aware that you're concerned about how the exercise of the rights that the landowners retain could affect the conservation values. And then some of those reserved rights will need to be addressed in specificity. There are a few that we know the IRS has directly challenged. One is floating building envelopes. A lot of times the landowner knows when they're doing a conservation easement, I know I want to build a house, I just haven't decided where yet. So we'll write in the conservation easement that the landowner gets to later select a building location subject to the approval of the land trust. The IRS is taking the position that merely the right of approval of the land trust is not sufficient to protect the conservation values, that there must be some sort of criteria by which the land trust makes this decision. So if the location of the building envelope is going to be decided later, stick some sort of criteria in the conservation easement how the land trust will decide. 300 feet away from stream corridors, outside of endangered species habitat as mapped in the baseline report, outside of high quality native grasslands as mapped in the baseline. So don't just leave it up to the land trust discretion, put some sort of criteria in there to locate the building. Similarly, with particular natural resources to be protected, the IRS is getting real picky about documentation of the condition of the resource. An example is when a conservation easement protects water quality, the IRS is saying that if you're protecting water quality, the baseline report has to have water quality samples in it. So we are recommending that this be phrased that the conservation easement protects water quality and quantity through watershed protection. And then in your watershed protection, you can explain in the baseline that you're limiting the amount of surface alteration, you're limiting where and how much vegetation can be cut, you're keeping activities away from stream corridors and recharge features and so on. The IRS does not put as much faith in land trusts to stick to our mission as we do. We probably need to limit the number of items in a conservation easement that are left up to land trust discretion, where it says, for example, the grantor is limited to 3 stock ponds unless the land trust approves additional stock ponds. Probably need to limit the number of things in the easement that are up to the land trust discretion unless there are real clear guidelines for deciding that. And even then, you probably don't want a dozen and a half things left up just to the land trust discretion, because the IRS sees that as kind of squishy conservation and not permanently protected as the IRS code requires. My last topic is conservation easement amendment. There have been a number of requests for amendments lately, but I'm talking about amendment, about the drafting of the amendment clause in a conservation easement. I'm seeing amendment clauses floating around that don't prohibit amending the conservation easement in a way that could convey what's called private benefit. Public charities like land trusts are, under our charter, supposed to act in the public interest, and we're not allowed to convey private benefits on individuals unless it's very much in line with our mission. For example, the landowner has 3 kids, and they sign a conservation easement that gets recorded that allows them to have 2 building envelopes. A few years later, they come back and say, I made a mistake. I need a building envelope for my 3rd kid. I need to amend the conservation easement. That addition of the 3rd building envelope would increase the market value of the property. That would be conveying a private benefit. The land trust probably can't do that without putting itself at risk of losing its charter. So for the land trust, I recommend that you put a clause in your amendment section that prevents amendments that confer private benefit. This is an opportunity for the land trust when you're sitting down to discuss the conservation easement with the landowner to say, Mr. and Ms. Landowner, do you have everything in here reserved that you want to do? Do it now, because if you come back later and ask for it, we might be able to do it, but we might not. So let's get everything in there from the start. Final kind of drafting thoughts I have, big picture, I see 3 essential elements to conservation easement drafting. Those are the conservation easement text, and we've been talking a lot about that for the last hour and a half. They're conservation easement exhibits and the baseline documentation. I see these as 3 co-equal requirements that an equal amount of attention needs to go into each of these. Why do I say that? I've seen more than one conservation easement recorded with exhibits missing. The baseline documentation is becoming increasingly important as not only a means of creating a baseline for which we will protect the resources on the property, but also of the way of demonstrating to the IRS that this is a legitimate tax-deductible contribution. So I see those 3 things as equally important. And one overarching trump card that I would add to that is landowner relations. You can have all these things squared up, and if the landowner and the land trust aren't in communication, if they're not on the same page, it's going to be creating problems for both of them. So if you're with the land trust, I recommend every 6 months calling up your easement holder, your easement owners, and saying, you know, how's it working for you? Anything you want to ask us, and just keep that communication going. And you know, maybe that way you would find out, as Thomas was mentioning, that the grantor has passed on, and the family is now working out who gets ownership of the property, rather than you finding out 8 months later when you come for your monitoring report and find out that they built a new barn in the wrong place because they weren't familiar with easement. So blah, blah, blah. This is what it all comes down to. You know, all the words and all the laws and all that stuff. This is what it's about. So that's all I've got. Allison's next. Okay. Allison, can you ask me a quick question?
You said that putting in the baseline that the exercising of reserved rights will not affect the conservation values. Why does it go in the baseline? Why not in the easement?
Because the way the regulations read. The regulations say that whenever the grantor reserves rights in the property, that they must create a baseline of the condition of the property, and this baseline are the conservation interests that the easement is to protect. So, you know, we can do it both places, but you can put evidence. You know, you can put biologist surveys and things like that in the baseline. And you know, I think this is going to involve some interaction with the baseline writers as well. You know, if it's biologists putting reports in, we may be talking to them about little snippets that they add to help with the IRS review. Don?
Burgess said a time or two about IRS getting more aggressive.
Yes.
How does that play with, like, clawback? Does that go backwards as far as well as forward? If they get more particular, are they allowed to do that on things that they've already approved?
Well, there's a 3-year statute of limitations for them to challenge a deduction. So anytime within 3 years after the year that the easement is recorded, they can come back and audit. But after that 3 years has passed, unless they're intending to claim fraud, and you know, who knows what they're going to do. Once that 3 years is gone, they can't audit. I don't know if I'm answering your question.
Well, some of the things that would be allowed or not allowed. You said they're more aggressive, so I assume that they're not allowing some things now that they used to allow.
They're coming up with new and creative ways to deny deductions.
Does it go back? Does it claw back?
I think the answer is probably yes, if it's within the 3-year period where they can challenge a deduction. If I'm not understanding you, let me talk to you after.
I have a quick question. This might be more of a Jeffrey's question, but in the case of the two building sites being allowed, wouldn't that have already been accounted for when the appraisal was done? And wouldn't it have been appraised, the value of the easement appraised for less by retaining 2 building sites?
Well, it definitely will, but if you go back and add a 3rd building site, that's when you're going to have that's going to increase the value of the property, and they've already taken a deduction for an easement with only 2 building sites. So.
Quick question I have that I kind of sort of have something going on similar to this. You have a conservation easement on the property, and they were allowed 2 building sites, and they have bought a property next door. They own 1,000 acres. They bought 400 more, and they'd like another building site on the original easement, but in return they will put an easement on the other 400 they've just purchased. What's your thoughts on that?
Difficult question. Okay.
Because you can't really, well, what I was told by someone I worked with said that you probably wouldn't want to do that, even though you'd be a plus in the easement column, because the first easement was meant to protect this, but I still.
If you're taking existing property out of conservation easement, even though you're adding other property, it at least would have to pass public review, Attorney General or court review. And I'm going to have a little bit to say about that in the emerging issues session on Friday. But that's a difficult question, and there's a recent court case, the Belt case, that makes exactly what you talked about more difficult.